Yes, Ms Littler.
Thank you, my lord. My learned friend relies on two authorities in which the court has read across the authorities on Part 36 and reserved costs by reason of the existence of an undisclosed callback offer. And those authorities are Dinglis and Tullett. And I should say that neither of these authorities were relied upon at the hearing below or drawn to Judge Thompsell's attention by counsel for the appellant. Dinglis and Tullett are both first instance decisions. They carry no more weight than the decision of Judge Thompsell, and your lordships are not bound by them. But in any event, it does not appear that the point was fully argued before the judge in either case. So if we can start by looking at Dinglis, which is behind tab 18. At paragraph 2 of Dinglis, your lordships will see in the middle of that paragraph, it seems to be common ground that the proper approach is summarised in multiplex, and the court quotes, sets out that quote. And then at paragraph 3, the respondents in this case invite me to adopt the same approach to offers made without prejudice, save us costs, and I agree that it's the appropriate course to take. But the judge doesn't give any reasons why it's the appropriate course to take, and doesn't appear to have considered either the wording of Part 44.24 or the principal differences between Part 36 and call to bank offers that I outline before you today.
Yeah, and multiplex, of course, was a Part 36 case.
It was, yes. Then, in relation, then if we can turn to Tullett, which is behind tab 10, and in particular to page 94 of the bundle. At paragraph 6, the court refers to HSS hire services, which again is a Part 36 case to do with payments into court. And then at no point seems to have been taken by counsel for the claimant that this case dealt with Part 36 and not with call to bank offers. And then at paragraph 7...
Sorry, just before we move on, is Shepherds and Walters another Part 36 case? Do you know offhand?
I don't know, but I don't, I'm afraid.
HSS and multiplex are?
Yes.
Yeah.
And what's said at paragraph 7 is, I'm satisfied it would be plainly wrong to make any order in respect of costs incurred after the 19th of October, so the expiry of the offer. And I do not think that in the end Mr Onions, who was counsel for the claimant, pressed that submission. And if we can turn over the page to paragraph 8, we get a hint as to perhaps why that point was not pressed by counsel for the claimant. When we look halfway down the page, and what's said is the claimants are a substantial company, well able to carry the costs of even this litigation without straining their resources. So, my lord, in neither of these cases did the court really grapple with the principal differences between the two regimes. And in fact, the court doesn't appear to have really heard any arguments as to what the differences between the two regimes are. And so I say, my lords, that it is not possible to deduce from either of these cases a reasoned proposition that call-to-bank offers should be treated as equivalent to Part 36 offers when it comes to determining the costs of the first stage of a split trial.
Well, the judge gives two reasons, doesn't he, for his decision. First is the claimants won't recover an overall balance, and he says he can't know how real, that is, without looking at the offers. And the second is if the claimants get an order for their costs after the relevant period, then there will be some deductions.
Yes.
And is that goes to his findings in paragraph 5, does it? Findings against the claimants in respect of the claimant's intention at whiteboard meetings, is that what he's talking about? So he seems to be saying that if he were to make a cost, or if the claimants were to get their costs, there would be deductions to reflect what he found on that issue, I think.
Yes, I think in paragraph 8 he's just talking about the pre-offer costs.
Yes.
Because it had been accepted on both sides.
Yes, post-offer cost should not be awarded. Mr Onions accepted that.
Exactly, yes. And so he's not making a principled decision that it would be wrong for him to decide the post-offer costs. He's simply not addressing himself to that because the parties have agreed he shouldn't. But what he's considering is whether it will be proper to make a pre-offer cost order.
Well, he might have thought the claimant was in a stronger position over the pre-offer costs, but he still refused to make it.
Yes, and I'll come back to the question of whether the court should make a pre-offer cost order in due course. But it's relevant to note that one of the reasons that he gives for not making a pre-offer cost order is that the claimants are a commercial party who can afford to bear the cost of the litigation until its conclusion, which I say is not a consideration that applies here. In fact, quite the opposite.
Your point is that this was an exercise of discretion and it wasn't an automatic rule applying CPR. He took into account impecuniosity or resources,
yes,
and he took into account the possibility that the claimants would not overall recover a balance of costs. So they were just factual matters, the circumstances of the case.
Exactly, in relation to the pre-offer costs. In relation to the post-offer costs, I say there's no principled decision at all because he's just doing what the parties have said he should do.
Right.
The second principled basis upon which a Part 36 offer should be treated differently to a called-a-bank offer is that a defendant who makes a Part 36 offer must agree to pay the claimant's costs if the offer is accepted. And Your Lordships touched on this issue in the questions that you asked of my learned friend. By making a Part 36 offer, a defendant accepts the automatic cost consequences of Part 36, which include, pursuant to CPR Rule 36.13(1) and 3, that the defendant automatically incurs a liability to pay the claimant's costs in the event that his offer is accepted. And that was the deemed cost order that my Lord took to earlier. The consequence of this is that where you have a substantial piece of litigation, a defendant making a Part 36 offer automatically exposes themselves to a liability to pay a significant sum by way of costs in the event that their offer is accepted. And so one cannot make a wholly risk-free Part 36 offer because one is always assuming the liability to pay costs in the event it's accepted. By contrast, when making a called-a-bank offer, there is no requirement that the defendant makes any offer at all in respect of costs. And that's why called-a-bank offers are frequently used as an alternative to Part 36 where, for example, a defendant wants to make a nominal payment to the claimant to simply make the case go away. Or where an example might be a drop hands offer. Importantly, a defendant can make a call-to-bank offer without exposing themselves to any real financial risk at all. And I say that that distinction between Part 36 and call-to-bank offers is important, because if call-to-bank...
Sorry, when you say financial risk, you mean as to cost, or because the offer's derisory and therefore is minimal as a risk in any event?
A defendant can make, in theory, a call-to-bank offer of £1 with no offer as to costs. That is an offer that one can make.
Or as you say, a drop hands offer.
Or a drop hands offer.
If you walk away from this litigation now, we won't sue you for the costs we've already incurred.
Exactly. And that is a risk-free offer in the sense that you do not have to pay any money to the claimant if it's accepted. If call-to-bank offers are to be treated as having the consequences contended for by my learned friend, there is nothing to prevent a cynical defendant from making a bad faith, lowball offer in relation to the whole of proceedings with no provision for costs as a means of oppression for the sole purpose of depriving the claimant of costs to which he would otherwise be entitled until the conclusion of proceedings.
Could they do that after a draft judgment is sent out one day before judgment is due to be handed down?
I don't think, well, there's no limit on when you can make a call-to-bank offer.
It seemed to be implicit in Mr Campbell's submissions that the mere fact that you've made it stops any cost assessment, cost order in its tracks.
Quite. That must be the conclusion, because it, and I'll come on to that, to this in my third set of submissions, but this is a case in which there are no factors in favour of Mr McKeown when it comes to the question of whether there should be an immediate cost order or not. The only factor that is potentially in his favour is the existence of this offer. And so if this appeal succeeds and costs are reserved, it's very difficult to imagine a situation in which the court would not have to reserve costs merely by virtue of the existence of an undisclosed global call-to-bank offer. I say that allowing a respondent to use a derisory call-to-bank offer to defer the payment of cost risk causes real injustice, or risk causing real injustice, which I say is particularly amplified in unfair prejudice petitions. And again, I don't say this exclusively in relation to unfair prejudice petitions, but I say that unfair prejudice petitions do have certain characteristics which makes this particularly problematic. Firstly, in order to get to the stage where the court is considering making a cost order in the petitioner's favour following a finding of unfair prejudice, the court has necessarily already found that there has been minority oppression of the petitioner by the majority. Allowing a respondent to further oppress a petitioner by using an undisclosed derisory call-to-bank offer to keep her out of cost to which she is entitled until the conclusion of proceedings would compound that oppression. Secondly, it deprives a petitioner of the cash flow benefit of those costs during the valuation stage of proceedings in circumstances where the majority versus minority nature of unfair prejudice petitions is such that there is frequently financial asymmetry between the parties. I have a submission in relation to informational asymmetry, but there is also financial asymmetry between the parties. An unscrupulous respondent can exploit this by conducting the proceedings unreasonably so as to drive up costs of the first stage of proceedings and then make a lowball call-to-bank offer to prevent the petitioner from recovering those costs until the conclusion of proceedings. So, my lords, as a matter of principle, I say that there are important distinctions between Part 36 and the called bank offers when it comes to determining the costs of a split trial. I also say that, in particular in the context of unfair prejudice petitions, there is no injustice to be caused to a respondent by not affording called bank offers the same status as Part 36 offers. And I say that because a respondent to an unfair prejudice petition has established mechanisms for protecting themselves in costs. Now, we've already looked at in some detail at the Part 36 regime, and as the judge observed at paragraph 32 of his judgment, it would have been open to Mr McKeown or any other litigant wanting to protect themselves in costs to make a Part 36 offer. But in the specific case of unfair prejudice petitions, there is also the well-established mechanism for a respondent to give themselves cost protection against a petition, and by making an offer to purchase the petitioner's shares pursuant to the decision of the House of Lords in O'Neill and Phillips.
Can you make an O'Neill and Phillips offer as a Part 36 offer?
That's an interesting question, my lord. The answer is I can't see why you couldn't make an offer.
Part 36 seems to say you can make a Part 36 offer in whatever form you like. So if you said, this is a Part 36 offer, I offer to buy your shares at a price to be fixed by an expert, or whatever the thing is, wouldn't seem to be any reason in principle why you shouldn't. How it fits in with the consequences of accepting the offer is perhaps a little bit more difficult. But the obligation to pay, which you find in 36, 36:14. 36:14(6), unless the parties agree otherwise in writing, where a Part 36 offer that is or includes an offer to pay or accept a single sum of money is accepted, that sum must be paid within 14 days. I mean, it may be that if you make an O'Neill and Phillips type offer, you're not offering a sum, you're offering a formula. So that particular rule doesn't apply, and it does seem to say where the offer is or includes a sum.
My lord, it may be that when looks at the provisions of Part 36 in more detail, one comes to the conclusion that in fact an O'Neill and Phillips offer would not be appropriate for Part 36. But in my submission that makes no difference because we have the existence of the O'Neill and Phillips formula.
Yes, but I mean clearly you can make an open O'Neill and Phillips offer. Why could you not make an O'Neill and Phillips call-to-bank offer?
Yes, but that would be a called bank offer that only related to the first stage of proceedings.
Oh, I see.
So my submission, that you could do that, absolutely, but the judge would then be able to look at that offer when deciding...
Because it doesn't fix quantum.
Precisely. My lord, may I take you to O'Neill and Phillips and show you what is required for that type of offer? It's behind tab 5 of the authorities bundle.
Yeah. You want page 35 of the bundle?
Page 21, please.
21.
No, that's not right. Page 35, yes, you're quite right, my lord, I'm sorry. At F, if the petitioner was offered everything to which he's been held entitled, the respondent may, as in the case of the called bank letter, be entitled to say that the costs after the date of that offer should be borne by the successful petitioner, who ought to have accepted the offer and brought the litigation to an end. Then down at H, in the present case, Mr Phillips fought the petition to the end, and your lordships have decided he was justified in doing so. But I think that parties ought to be encouraged, where at all possible, to avoid the expense of money and spirit inevitably involved in such litigation by making an offer to purchase at an early stage. Then turning over page 36, and at C, at the bottom of C, it is therefore very important that participants in such companies should be able to know what counts as a reasonable offer. At D, in the first place, the offer must be to purchase the shares at a fair value. Then at the top of F, secondly, the value, if not agreed, should be determined by a competent expert. At the top of G, thirdly, the offer should be to have the value determined by the expert as an expert. At H, fourthly, the offer should, as in this case, provide for equality of arms between the parties, and that's important, my lord. Both should have the same right of access to information about the company which bears upon the value of the shares, and both should have the right to make submissions to the expert. That's an acknowledgement to my submission of the informational asymmetry that exists in these types of cases. Then fifthly, there is the question of costs. In the present case, where the offer was made after nearly 3 years of litigation, it could not serve as an independent ground for dismissing the petition on the assumption that it was otherwise well-founded without an offer of costs. But this doesn't mean that payment of costs need always be offered. If there's a breakdown in relation between the parties, the majority shareholder should be given a reasonable opportunity to make an offer before he becomes obliged to pay costs. So if you make your offer once the petition is on foot, then it has to include an offer to pay costs. But if you make your offer at the beginning of the dispute before any real costs have been incurred, then there's no requirement that it includes costs.
I don't think that's quite what Lord Hoffman's saying. If you look at the last sentence, the mere fact that the petitioner has presented his petition before the offer does not mean that the respondent was offered to pay the costs if he was not given a reasonable time. So you could have circumstances where it's perfectly reasonable to make an offer without costs, even after the petition has been presented. And in those circumstances, Part 36 wouldn't be a complete answer, because, as you've explained, you would have to take on a liability for costs incurred to date.
I understand this to be saying that if the I understand the essence of what's being said here, that the respondent should be given an opportunity before the dispute continues to make an O'Neill and Phillips offer without the payment of costs. But if he allows the dispute to continue and for costs to be incurred, etc., then at that point it would be unreasonable not to make an offer of costs as part of the offer.
You mentioned at 36, is it H, there's a reference to asymmetry of information. You were referring earlier to asymmetry of finance, and you said asymmetry of information. What is the point that flows from asymmetry of information in terms of policy and a decision to make or not make in order for immediate costs?
Well, I say that it's one of the factors that the court should take into account in exercising its discretion. And the reason that I say it's a problem that's particularly likely to arise in minority shareholder oppression, I don't say it could never occur in any other type of litigation, but it's a particular problem in unfair prejudice petitions, is because the respondents to an unfair prejudice petition are necessarily those with control of the company. And that being the case, they will usually be in the position of holding all of the financial information and documentation in relation to the company. And as we know, a company's articles of association will often provide that a shareholder does not have any right to that information just by virtue of their membership of the company.
Yeah. How does it feed into discretion, though? As to, I think you're relying upon it as a factor which would lead the court not to defer costs.
Yes.
Why is the fact that there's an asymmetry relevant to that point? I understand everything you said about the existence of asymmetry. That makes perfect sense. Why is it relevant to the exercise of discretion?
I simply say that under 44.2, the court's required to have regard to all of the circumstances, and the fact of there being asymmetry of information between the parties and extreme asymmetry of information is a relevant circumstance that the court is entitled to take into account in the exercise of that discretion.
I'm being dense. Why does it mean you shouldn't defer? That's all right. Take instructions. Someone will tell us the answer.
Yes. my instructing solicitor is quite right. And the relevance of it is that where you have asymmetry of information, the petitioner is in a position where she cannot, with any reasonable accuracy, estimate what the value of her shares are. And so when one is considering, at the end of the day, whether she should have accepted the offer or not, there is no offer that she could ever be penalised in costs of having turned down without the information that she would need to evaluate what her shares are worth. And so this goes to my learned friend's point about whether there might be any, whether if the court were to reserve costs, anything might happen at the end of the day to change the decision on costs. And if at the end of the day a petitioner can never be, or will not usually be penalised for having turned down an offer, even if she fails to beat it, because of this asymmetry of information, then the existence of that offer could never be something that would change the incidence of costs.
Maybe it works the other way. The fact that there's an asymmetry in favour of the respondent company means that they can choose what information to place or not place before a court and thereby game the system.
Yes.
I'm not saying that's necessarily this case. I'm just trying to think about it in abstract terms, why it's relevant as a factor which a court might take into account.
I think your point is just to take a hypothetical case in which the petitioner, as very often, wants to be bought out. The real battle is what assumptions you make when the valuer is instructed. And the respondent knows all the information the petitioner doesn't. The respondent makes a global offer saying, I'll give you 100,000 for your shares. Your point is the petitioner really doesn't have the material to know whether 100,000 is a fair estimate or a gross underestimate until they've gone through the process of the liability trial to find out what it is that the respondent has actually done with the company at a time when the petitioner, ex hypothesized, has been excluded from management.
Right.
And it's only once you've gone through that process that you can make a reasonable estimate of what you might get at the end of the day, so that even if at the end of the day 100,000 turns out to be a perfectly fair estimate of the value of shares, the petitioner could still expect to recover the costs of fighting the liability trial, because they have to go through that process to get to the stage at which they can evaluate the offer.
Exactly. And that's why the O'Neill and Phillips route to settlement of the unfair prejudice issue is so attractive in unfair prejudice petitions, because it enables the parties to bypass the costs of a very expensive trial to decide on the issue of unfair prejudice and to proceed directly to the question of valuation. And a petitioner can accept an O'Neill and Phillips offer without having to guess at what the financial records of the company might show that her shares are worth.
Can we just, I just want to pursue that point a little bit further, if I may, and stay away for the moment from callback offers.
Yes.
Think about a Part 36. Part 36 says if you don't beat the Part 36 offer, you pay the other side's costs from the date, unless it's unjust. And one of the things that the court considers in deciding whether it would be unjust was the information available to the party at the time when the offer was made. So your asymmetry point goes to that. That is a decision which is made after trial. So at the stage one point, how does that feed into the judge's exercise of discretion whether or not to make a costs order? He or she would say, well, bearing in mind how little the petitioner knows, I can be confident that it won't be unjust, or that it would be unjust to make her pay the costs at the end of the day? Is that?
Yes. So if the court, at the conclusion of the first stage of proceedings, is satisfied that there has been a serious asymmetry of information and access to documents, etc., then it is entitled to say whatever the contents of that call-to-bank offer might be, or whatever the contents of that offer might be. I don't think that the petitioner was given a fair opportunity to be able to consider whether it was an offer that she should accept or not, because she hasn't seen any of the financial records of the company. And if that's right, if it's not an offer that the petitioner could ever be penalised in costs for having rejected, then it can't make any difference to the question of cost when they fall to be determined at the end of trial, and so the court should be willing to, or it's one of the factors that the court can take into account in deciding to make an immediate order for costs.
So you distinguish this kind of case from, say, a personal injury case where you ought to know what damage you suffered,
Yes.
or a breach of contract case when you know what damage the breach has caused you. Here you don't know because you haven't got the information.
Yes. If a defendant's negligence has caused me to break my leg, I can go and look in that book, I think it's called Kemp and Kemp, which gives you the range of different outcomes.
And you know your loss of earnings and future care and all that stuff.
Exactly.
At least you can work it out.
Well, you're in as good a position as the defendant to know what your damages are likely to be.
Exactly. The problem with this kind of case is that all the information that a petitioner would need to have in order to evaluate the reasonableness or otherwise of an offer is in the hands of the other side.
The same might well apply in an IP case where you can show infringement, but you have no idea what the quantum of infringing sales is.
Yes.
That's all in the hands of the defendant, and you might want to elect from account of profits, and you might want to elect for damages, but you don't even know how to calculate your damages until you know how many infringing articles they've sold.
Right. I'll come back, if I may, to the asymmetry of information point, because I think it's important to look at what the judge actually found in relation to the asymmetry of information in this case, because I say it is pronounced, and that is relevant. But for now, the point that I wanted to make is that an unsuccessful respondent to an unfair prejudice petition who chooses to do none of the things that I've just referred to, so doesn't make a Part 36, doesn't make an O'Neill and Phillips offer, but instead makes a single Calderbank offer in relation to the whole of proceedings, cannot then complain that he has not been afforded the same cost protection as if he'd made a Part 36 offer. He also can't complain that he must pay all of the initial petition costs, because those costs could have been avoided if he'd made an O'Neill and Phillips offer. My lords, I'd like now, if I may, to come on to the circumstances of this case. And these are dealt with at paragraphs 46 to 61 of my skeleton. And before I do that, I'd like, if I may, to just take your lordships to the ground of appeal in this case, which is in the core bundle behind tab 1 at page 15.
Yeah, just before you leave,
Yes.
the other thing a respondent could do, depending on the facts, is say, well, you've made 27 allegations of unfair prejudice against me. I'm prepared to settle it on the basis the first 3 are good and the rest are bad.
Yes.
So you could make a Calderbank offer limited to the liability stage.
You could make any kind of offer you wanted, my lord, in relation to the unfair prejudice aspect of the petition. And that offer would be taken into account at the conclusion of that first stage.
Because you could look at it at the end of stage 1.
Exactly. So, looking at my lords at the ground, which are at page 15 of the core bundle, the sole ground upon which this appeal proceeds is that the judge was wrong in the circumstances of this case in concluding that he should not treat without prejudice against cost offer in the same way as Part 36. My lords, the appellant has not identified any particular circumstances of this case which mean that the judge should have treated the Calderbank offer in the same way as a Part 36 offer. And in fact, at paragraph 47 of his skeleton, my learned friend concedes that there is no dispute that, but for the Calderbank offer, Mrs. Langer should have her costs. The only factor or circumstance that the appellant relies on as meaning that the judge should have reserved costs is the making of the offer itself. And so what my learned friend is effectively contending for is the proposition that the existence of an undisclosed call-to-bank offer is some kind of trump card that overrides all of the other circumstances and in and of itself requires that costs be reserved until it can be disclosed and considered, because the judge can't know until he sees the quantum of that offer whether it impacts on his decision of costs. My lords, as I've just explained, there is no rule that requires this, nor should there be. The exercise to be undertaken is the exercise of the judge's discretion, taking into account all of the circumstances. And in fact, in this case, there are a number of other relevant factors and circumstances, all of which, I say, support the judge's decision to exercise his discretion to make an immediate cost order. And so I say that when those circumstances are taken into account, it is clear that no offer Mr McKeown could have made could have operated to deprive the petitioner of her costs at the end of the day. Now, it's fair to say that not all of these circumstances are referred to directly or in any great detail by the judge in his judgment. But to the extent that this court is undertaking its own analysis and exercising the discretion afresh, we say that these are circumstances that can be taken into account by your lordship.
Well, we don't get there unless the judge's exercise of discretion is wrong. We don't get there unless the judge's exercise of discretion was wrong.
Absolutely.
The submission you're facing is a very simple one, which is where there's a call-to-bank offer, really, unless it's a most exceptional case, you have no option but to reserve. That's a submission you're facing.
I say that that submission is wrong, but because the relief that's sought in this appeal by the appellant is that your lordships should substitute your own order for an order that costs be reserved, I say that your lordships can only make that order that the appellant is seeking if you are satisfied that on a correct exercise of the judge's discretion, or considering whether the circumstances are exceptional, that cost should have been reserved.
Well, no, wait a minute. If the judge was not wrong in the exercise of his discretion, that's the end of the appeal.
Yes.
So are we now to assume, contrary to your submission, that the judge was wrong in the exercise of his discretion? We then have to decide what to do, one option being to remit it back to the judge, the other to make up our own minds. Now, so which of those possibly you're accepting for the purposes of this stage in your argument?
Yes.
Understood that the judge was wrong.
Yes.
So are you now dealing with the choice between remission and exercise of discretion, or are you going straight to the exercise of discretion?
Is your lordship asking whether the respondent wants the matter to be remitted, or whether...
Well, that's part of it.
Yes, because to answer that question, although I did say in my skeleton that we wanted the case to be remitted, I think having reflected on the additional costs that would be involved in doing that, actually we would be very happy for your lordships to exercise
All
the
right.
discretion.
So for this stage in your argument, we assume that the judge was wrong in the exercise of his discretion, and you are now inviting us to exercise a fresh discretion of our own.
Correct.
Right.
Taking into account all of the circumstances,
yes, of course.
which I'm now going to address you on.
Yeah.
But just so we're clear, if we're with the appellant, it's upon the basis that, on his analysis, impecuniosity or otherwise is irrelevant, conduct is irrelevant, merits are irrelevant, justice to the petitioner as opposed to the respondent are irrelevant. Then you say, well, if that's the case and the flip goes towards deferral, we can then consider that where there's exceptional circumstances. In those circumstances, does conduct and merit and everything come back into play, or have we kicked them out altogether?
Well, my
Rather
learned
depends
friend-
upon what we find, I suppose. Doesn't it?
My learned friend seems to be making the submission that what multiplex says is that the only exceptional circumstances will really be where the offer doesn't apply to the costs that are the issues that are being decided. And in my submission, that can't be right, because if the offer doesn't apply to the issues that are being decided, then it's it's irrelevant. It doesn't have to be considered at all. There must be exceptional circumstances must mean something wider than just the offer doesn't apply. And so what I say is, if your lordships are exercising the discretion under 44.2, these circumstances are relevant to the exercise of discretion. If your lordships are with my learned friend and what you're really looking at is part 36, then these matters are exceptional circumstances. And that either way, the correct decision on costs is an immediate cost order.
And we simply take the facts as found by the judge in relation to merits, conduct, and financial implications, because you're right, they're terse, but they are set out.
And I should say that although these matters aren't necessarily given a great deal of time in the judgment, they are matters that were before the judge, with the exception of some of the information relating to what's happened since, which I'll deal with when I deal with impecuniosity. Everything was before the judge. So the fact that he didn't refer to it in his judgment doesn't necessarily mean he didn't consider it. So firstly, if I can deal with conduct, the conduct of the appellant, and this is dealt with at paragraph 47 of my skeleton. The conduct of the parties is one of the factors that the judge is expressly required to take into account when determining what cost order to make pursuant to part 44.24. And pursuant to part 44.25, the conduct of the parties includes that B, whether it was reasonable for a party to raise, pursue or contest a particular allegation or issue, and C, the manner in which a party has pursued or defended its case or particular allegation or issue. So my learned friend takes the position that the matters which I refer to in paragraph 47 of my skeleton are merely factors justifying a cost order being made in the appellant's favour on the indemnity basis. I say that's not right. Firstly, the petitioner was entitled to her costs by virtue of having succeeded on the petition. Secondly, matters going to the question of whether a party should have their costs on the standard or the indemnity basis are also relevant to other questions of costs, including whether a party should have their costs in any event or at all. And we're not just talking here about a lying witness. This is unreasonable conduct that ran all the way through the litigation and which the judge found served to unreasonably increase costs. So if we can look at paragraph 15 of the judgment, which is in the core bundle at tab 6, and page 53. At paragraph 15, the judge says, Ms. Lintner has put forward various reasons why I should award costs now. And he summarises those reasons in 3 lines. But, my lords, those reasons appear in more detail in my skeleton for the consequentials hearing, which is in the supplementary bundle at tab 9. Page 165. At paragraph 34, which begins, there are a number of extraordinary factors in this case that justify, indeed require, the making of a cost order at this stage. And I'd invite your lordships to read paragraphs 34 to 37 of my skeleton, because those are the reasons which the judge found generally persuasive. going back to paragraph 16 of the judgment, the judge goes on to say, even if the respondent is successful at the next stage in showing that the valuation to be placed on the shares is much lower than expected, the fact remains that the petitioner has been put to considerable effort, expense and delay through the respondent taking points in relation to liability which have proved to be without merit, and the petitioner in such circumstances should be entitled to her costs in relation to this stage of the proceedings. The clear implication here, I say, is that the judge was of the view that even if the petitioner is awarded only nominal damages at the valuation stage, she should still be entitled to her costs because of the conduct of Mr McKeown and his legal representatives. And I say that that applies with equal force to any submission that might be made, that the petitioner should have her costs at the end of the second stage of proceedings. Sorry, the respondent should have his costs at the end of the second stage of proceedings, and by reason of an undisclosed Calderbank offer.
But at this stage in the judgment, the judge is not considering the impact of an offer.
No, he's not.
So, of course, if you have a split trial, no offers of any sort, claimant wins on liability and you move on to quantum, of course you'd expect the claimant to get their costs of the liability hearing. And that's what the judge is dealing with here, because he says in the next paragraph, paragraph 17, take the view then that subject to any other considerations is open to me to award costs at this stage. Then he goes on to consider the open offer, 25,000, says, well, that's not good enough. And then he goes on to deal with the Calderbank offer.
Well,
you don't get from the judge, I don't think, any statement which approximates to, well, even if I were to take this offer into account, the conduct is so unreasonable, I would override it.
My Lord, the way in which the Mr McKeown's counsel opposed our application for costs below was primarily on the basis that Mr McKeown it was likely that he would go on to succeed in establishing that the petitioner's shares were valueless. And so I say what the judge is doing here is actually dealing with that point, because he says even if the respondent is successful at the next stage in showing that the valuation to be placed on the shares is much lower than expected, the petitioner should still get her costs because of his unreasonable conduct.
It sheds a light on how serious the judge thought the misconduct was.
And so if the judge was satisfied that even if the petitioner doesn't recover anything for her shares, at the end of the day she should still have her costs because of Mr McKeown's conduct, then he doesn't say this expressly, but it strongly suggests that he considered that that the fact that she failed to beat a Calderbank offer would also not change the incidence of costs.
Right.
The judge's disapproval of the conduct of Mr McKeown and is reflected in the fact that the judge ordered that the majority of the petitioner's shares were awarded on the indemnity basis. And that included 5 out of the 6 expert reports dealing with all of Mr McKeown's disclosure and the PTR trial preparation and trial phases of the petitioner's cost budget. And he gives his reasons for doing that at paragraph 34 of the judgment. In the fourth line down, he says, Ms. Lintner, on behalf of the petitioner, set out a number of points as to the conduct of the respondent and his legal team in relation to the matter which I recognise from my involvement in the trial at its first stage, and particularly many points regarding the lateness and presentation of financial evidence. I do not think that the respondent has met the standards that would be expected of a professionally advised litigant in dealing with these matters, and I accept that this has involved additional cost on behalf of the petitioner to an unusual extent that warrants costs being awarded on the indemnity basis, at least part of what the petitioner has asked for. My Lords, it would be a fairly extraordinary outcome if conduct justifying the penalty of indemnity costs could be confused or overridden by the existence of a global Cold Bank offer. And I say there is no offer that Mr McKeown could have made in June 2020 that could have operated to deprive the petitioner of her costs, given his conduct during the first stage of proceedings. There is a further point to be made in relation to the award of indemnity costs against Mr McKeown.
Can you remind us of the chronology? When was this 9-day trial? When did it take place?
November 2020.
November 2020, and we were told this morning that the Calder Bank offer was made at the end of May.
That's right, yes.
You have no objection to us knowing the date?
No.
And when was the petition issued?
The 2nd of April 2019.
Thank you.
And I should say that of the phases of the petitioner's costs budget on which in relation to which indemnity costs were ordered, the expert reports, PTR, trial preparation and trial all came after the expiry of the offer.
Yeah.
And presumably between them make up the bulk of your presentation budget.
There's a further point to be made in relation to the award of indemnity costs. If the question of costs of the first stage of the proceedings is reserved until the conclusion of the valuation stage, Mrs Langer will be forced to incur all of the significant additional costs of going through the valuation stage to get to the point where Mr McKeown's unreasonable conduct during the first stage of proceedings can be considered by the court and penalised in costs. Firstly, I say that's not in keeping with the approach that's endorsed in paragraph 13 of the new Practice Direction 3E, which enables the court to penalise a party for behaving oppressively in seeking to cause an opponent to spend disproportionate sums on costs as and when that conduct arises. So under paragraph 13 of the new Practice Direction 3E, which came into force, I think, in October 2020, so after, too late for the petitioner in this case.
Sorry, this is practice direction
3E, paragraph 13.
3D.
3E. It's on page 224 of the White Book.
Yeah.
Now, this provision was introduced too late for Mrs Langer, but the clear message that's being sent is that unreasonable conduct which causes a party to incur unnecessary costs should be dealt with when it occurs, and that the victim of the unreasonable conduct should not be forced to wait until the conclusion of the proceedings to have that conduct penalised. There are two additional problems with forcing Mrs Langer to wait until the conclusion of proceedings for Mr McKeown's unreasonable conduct to be dealt with. And this goes to my learned friend's submission that the court should simply hold the ring. Now that might be relevant where you have two commercial parties who can afford to bear the costs of the kind of cash flow and benefit or risk until the conclusion of proceedings. But there can be no holding the ring in this case. There is no holding the ring. Firstly, Mr McKeown's position is that he is insolvent, as evidenced by his recent IVA proposal in which he was offering creditors 1.83 pence in the pound. Mrs Langer will therefore be forced to incur all of the additional expense of fighting the valuation stage in order to get to the position where Mr McKeown's unreasonable conduct can be considered, in circumstances where, on Mr McKeown's own case, Mrs Langer will be unable to recover those costs from him because he's impecunious. That cannot, in my submission, be in accordance with the overriding objective of dealing with cases justly and at proportionate expense. Secondly, at the appellant's request, Judge Thompsell recused himself after making the interim payment order. There will therefore be a different judge hearing the valuation stage, if it goes ahead, and determining costs at the conclusion of proceedings, which I should say is not likely to be until at least 2 years after the November 2020 trial. Those proceedings are currently stayed, so it's inconceivable that the that the proceedings will be concluded before the end of next year. He or she, the judge hearing the valuation stage, will not have the benefit of having been present at the first stage of proceedings, of hearing the evidence, or of witnessing the conduct of Mr McKeown and his legal representatives firsthand, and therefore, in my submission, won't be able to properly assess the conduct of Mr McKeown when they come to determine the issue of costs.
Why not? Why can't the judge at stage one, and let's assume you're wrong, that the judge should reserve cost. He surely would be able to say that for the benefit of the cost judge or trial judge, I find the following conduct in the course of this trial unreasonable, and were I to award costs, I would do so, I would have done so on the indemnity basis. Why can't he make that kind of finding?
Because the judge who is then having to weigh up the various competing factors will not have the benefit of having seen any of this firsthand. And so...
No, you'll have to take the first judge's findings on trust.
Yes. Well, in my submission, that would be prejudicial to the petitioner, because the reality is that all of the matters that led to Judge Thompsell making an indemnity cost order are likely to simply get lost and not be given the weight that they deserve if costs are reserved.
Why did the judge recuse himself? Did he not reserve it to himself, or did he recuse himself?
He made an interim payment order in respect of the value of the shares of £200,000. And it was the submission of Mr Tager, who was acting for the respondent at that time, that on that basis the judge had to recuse himself from hearing the valuation stage because he had made an assessment of what he thought the minimum likely value of the petitioner's shares would be for the purposes of determining that application.
Right.
That rather throws into sharp relief that the respondent could, if he'd thought it all through, have said, well, I'm willing to show you my without prejudice, my call to bank offer, because you're not going to be the trial of the judge on quantum, but I don't want you to show that judge.
Yes, quite. The sequence of events was that we had made the interim payment application at the time the cost hearing took place, but the determination of the interim cost payment application didn't take place until after the cost hearing, and that was when the judge recused himself. So it's fair to say that the respondent could have said to the judge, you can see my offer and then you must recuse yourself, but the judge hadn't already recused himself.
Yeah, but he could have said, since there's this outstanding interim payment application, you should decide that. And then I'll decide whether to waive privilege in the offer I've made, on the basis you're not going to be hearing the quantum.
Yeah. Coming back to the asymmetry of information point, there is a related issue in unfair prejudice petitions, which is that unlike most Part 7 claims, the relief that the court can order pursuant to Section 996 of the Companies Act is extremely wide. And that much is evident from the relief that the judge ordered in this case. The terms of the buyout order were completely bespoke. They involved the court creating a hypothetical company with certain attributes, liabilities and assets, and then ordering that the petitioner's shares be valued as though they were shares in that hypothetical company. And the date of valuation, which in this case has a huge impact on the value of shares, was also one decided on by the judge and not one that had been contended for by either party. And so, compounding the asymmetry of information issue I referred to earlier, because of this very wide discretion, it will very rarely be the case that a petitioner to an unfair prejudice petition could with any reasonable accuracy, predict what the outcome of the petition is going to be. because until one has got to the end of the unfair prejudice stage, one simply doesn't know what the remedy that's going to be ordered is. And it really is as last minute as that. I mean, we did not know what the terms of the buyout order were going to be in this case until we got the draft judgment. There were terms of the buyout order that weren't even discussed really in the November trial. And so I say that that compounds the uncertainty for the petitioner and makes it even more difficult for her to assess whether an offer, a global offer to settle the proceedings as a whole, is a reasonable offer and one that should be accepted.
That uncertainty also applies to the respondent. Not knowing the way the judge will see it applies to both parties.
Yes.
So it's not so much an asymmetry, it's just a lack of being able to predict how judges will see a case.
It was common ground at trial that Mrs. If I can now address you on the particular asymmetry issues that arise in this case. It was common ground at trial that Mrs. Langer was comprehensively excluded from the Sophisticat's business from April 2018, and that she didn't have access to any of the financial records of the company. Mr McKeown refused the petitioner's request for pre-action and initial disclosure, and so we only started to get documents during this case during the course of disclosure, which took place over a long period of time and on a very piecemeal basis. Even by the time we got to trial, the financial state of the company was extremely difficult to ascertain. And so if I can take you, my lords, to the liability judgment, which appears in the supplemental bundle, behind tab 1. On page 15, at paragraph 86, the judge found that the financial information, despite the best and skilled efforts of both counsel and the accountancy experts engaged, is difficult to grasp. This, to my mind, is largely because of the unsatisfactory way in which Mr McKeown kept accounting records, a point I will return to below. Paragraph 87, the petitioner complains with good cause that a great deal of financial evidence was disclosed late and with inadequate explanation. In particular, at one stage, very shortly before the valuation experts were due to make their reports, a spreadsheet was served, which the respondent relied on in the proceedings as being an accurate balance sheet, and which he considered rendered the balance sheets previously provided as being, in the respondent's own description, rubbish. The lateness and lack of explanation of the significance of this spreadsheet was unfair to the petitioner. However, the petitioner's legal team and accountancy expert did exceptionally well in dealing with it. Then at page 22, at paragraphs 119 to 123, the judge made a number of comments about the way in which the companies were managed, including at 120, it's apparent that this was part of a pattern of an approach to accounting under which Mr McKeown paid little regards which company or individual might be the proper owner of any funds or the proper person responsible for making the payment. At paragraph 122, it's only with the greatest difficulty that the correct treatment of payments can be discerned. At the bottom of that paragraph, however, even with the benefit of his explanations, these financial arrangements were not readily understood. And then at 123, 3 lines down, this cavalier approach to accounting and stewardship of DRL's cash fell far short of the duties he had as director to keep proper books of account. The financial position of the companies at any point could only be determined with the benefit of expert forensic accountancy and with the full cooperation of Mr McKeown, both in explaining entries on ledgers and in reconciling these between the various corporate bank accounts involved and his personal bank and credit card accounts. So even at trial, looking at the documents that were disclosed, it was extremely difficult to work out what was going on in the finances of this company. And I'd invite your lordships also to look at paragraphs 271 to 272, where the judge found there had been an inadequate and labyrinthine approach to accountancy. Put simply, there was no way that the petitioner could reasonably have determined whether any offer that Mr McKeown put to her in June 2020 was a reasonable one which she should accept.
Well, any cash offer.
Any cash offer, yes.
A formula offer might well have been reasonable.
Yes.
We don't know whether it was or it wasn't. And we can't speculate.
Well, my lord, we know it wasn't an offer that just compromised the first part of the proceedings. We know it was an offer that related to the whole of the proceedings,
Yeah,
including the valuation stage.
sure.
The asymmetry of information point was acknowledged by the judge in his reasons for refusing permission to appeal, at paragraph 39, which we looked at earlier, finding that there was force in the respondent's informational asymmetry point. Now, my learned friend contends that we're not entitled to rely on this paragraph because it doesn't form part of the judgment. I accept that we can't rely on it in seeking to defend the judge's reasons for making the cost order because it doesn't form part of those reasons. However, where this court is being asked to form its own view as to what the appropriate cost order should be, I say that the court is entitled to conduct a wider examination of the material before it than just looking at the judge's reasons for making the order. My learned friend makes a number of points in relation to this argument, and I'd like to just address you briefly on those that I haven't already answered. Firstly, he says that such a submission could not be made in respect of a Part 36 offer because of the wording of Part 36.17. With respect, that ignores the primary issue in dispute between the parties, which is whether Part 36 should apply to this case. Secondly, he says that even if the petitioner has difficulty evaluating the terms of an offer, its terms might be sufficiently generous that she should be penalised for her failure to accept it. To this I say that although we can only talk in hypothetical terms about the called bank offer, and we must not speculate as to its terms, the judge was entitled, as he did at paragraph 39, to approach the offer, the undisclosed offer, with a degree of realism in the context of the case. So what the judge said was, I find it very difficult to believe that there could have been an offer that was made that the respondent would have been happy to make, given the respondent's view on valuation, which was nil, that the petitioner could ever have been able to assess as being a reasonable value. So I find it extremely unlikely that if I were aware of this offer, it would alter the decision I've come to today. And I say that that realism is an approach that the judge is entitled to have.
What is the difference between speculating on something you can't see and forming a view as to what it might realistically say?
Well, for example, it goes to whether it was reasonable for the petitioner to refuse it. So, for example, I think we can agree without disclosing anything about the terms of the offer that it probably wasn't an offer for £1 billion. And when the submission is being made that there comes a level of offer that is so attractive that regardless of any other consequences, the petitioner should be, any other circumstances, the petitioner should be penalised for not accepting it. I say that when considering that submission in particular, one is entitled to have a degree of realism about what offers the parties might reasonably have been willing to make. Not about what the specific offer itself was, but about the spectrum of offers which a party might be willing to make.
That's a rather slippery slope, isn't it? I mean, quite often you find in these sorts of cases that somebody puts a value of, say, £1 million on the shares, and somebody else puts a value of, say, 5 million on the shares. The experts are working on slightly different assumptions. And you might well say, well, I don't think the shares are worth more than £1 million, but I'm prepared to split the difference with you and pay for 3. So I'm not sure that you can draw a great deal of comfort from what is being said openly by the respondent or indeed his experts in terms of trying to second guess what an offer might be.
Yes. I expressly do not contend that the court should speculate as to the terms of the offer. I simply say that when one is considering the existence of an undisclosed offer, one is entitled to have a degree of realism.
Well, yeah. I think you have better points than that, if I may say so.
My learned friend also says that to embark on an inquiry into the reasons why a party did not accept an offer in the middle of the proceedings is likely to lead to satellite litigation. With respect, no such inquiry is necessary as to why the petitioner actually rejected the offer. The only question that might be relevant is whether the nature of the proceedings is such that she could ever be penalised for having rejected the offer. And we say it's plain on the basis of the judge's findings and the liability judgment that she couldn't. And then finally, my learned friend's fourth argument is that the court should simply hold the ring until the conclusion of proceedings. But with respect, that ignores the very real prejudice caused to the petitioner by delaying or reserving the court's decision on costs. Reserving costs in a case like this does not hold the ring. It will likely have the effect of permanently depriving Mrs Langer of costs to which we say she's entitled, and even on Mr McKeown's case, a cost to which she may be entitled, for the reasons that I've given. And she'll have to incur huge amounts of additional costs to get to that point. The third circumstance that I rely on, my lords, is the appellant's unreasonable refusal of the respondent's open offers to bypass the November trial. And this is dealt with at paragraph 49 of my skeleton. I'm at this point going to address you only in relation to the open offers made by Mrs Langer to compromise the first stage of proceedings. There was also without prejudice, savers to costs offer made in relation to which there's a separate point to be made, which I'll come on to. I'd ask your lordships to bear in mind this is a case in which Mr McKeown has, since the very outset of proceedings, contended that Mrs Langer's shares in the Sophisticat's business are worth absolutely nothing. And that's a position he's made clear he intends to pursue at the valuation stage of proceedings as well. Now, if that's a position that Mr McKeown takes in good faith, one would have thought that Mr McKeown would be willing to either make an O'Neill and Phillips offer to proceed directly to valuation, or to otherwise dispose of the November trial by consent and proceed directly to a valuation of Mrs Langer's shares, which he says will show that they're worth nothing, and so he has nothing to pay. If I can take your lordships to the open correspondence, which is at tab 14 of the supplemental bundle. The chain of correspondence begins at page 217, but all of the correspondence between page 217 and 229 relates to a suggestion that Mr McKeown would purchase Mrs Langer's shares based not on an independent valuation, but rather on the Walton Dodge valuation, which your lordships will recall is referred to in the December 2020 main judgment, and it's a paragraph 60 for your information. And the Walton Dodge report was the report that valued Mrs Langer's shares at £25,000. And the judge found that the £25,000 offer wasn't capable of affecting his position on costs, and so we say that that correspondence is irrelevant. The first relevant offer is at page 230. This is Russell's 23rd of August 2018 letter, so this was pre-issue. And page 232, there is a buyout proposal. It's essentially a reverse O'Neill and Phillips offer. In fact, it's more, this offer that was made is more advantageous to Mr McKeown than the buyout terms that were ordered by Judge Thompsell, because it doesn't take into account the Euston Club. My lords, in the face of the informational asymmetry that Mrs Lang was faced with, where she was denied access to the true financial records of the company all the way up until trial, this was all she could reasonably have been expected to do: to offer an independent valuation expert be given full access to the books and records of the company to work out what her shares were worth. That offer was not accepted. Brooke Martin's response is at page 236. 7th of September 2018, they make the offer of £25,000 based on the Walton Dodge report, and then over the page, penultimate paragraph, they say our client is prepared to discuss this proposal, but we must warn you that Mr McKeown will insist on any valuation being based on the current as opposed to historic value of the company, bearing in mind by this point the Soho Club had already been removed from the company by Mr McKeown. And if your client is able to advance fully particularised allegations of misappropriation and the like, the company and Mr McKeown will insist on those allegations being determined in open court and resolved by a judge and not in the way you suggested.
Yeah, well, the problem comes about because of the assumption that you put in your offer on page 233, subparagraph E, on the basis that the company and its subsidiaries had not been run in a way which was unfairly prejudicial, in consequence 1, 2 and 3. So he's effectively saying, well, it wasn't run in a way that was unfairly prejudicial to your client, and if you want those assumptions, you better prove them.
Yeah, but he lost on all of those points, my lord. So, in fact, this was an offer that he should have accepted. It was more favourable, these terms are more favourable to him than the buyout terms that he eventually ended up with, because they don't take into account the fact that he appropriated the assets and business of the Marylebone Club and set up the Euston Club in breach of his duties to the company.
Right, so your point then is that the judge in fact found these allegations proven, and that in itself is a reason why you should have your costs, because you'd offered to settle on this basis long before the petition.
Yes. We made an offer to settle on terms that were more favourable to Mr McKeown than the terms he's ended up with at the end of the November trial.
Yeah. Why do you say it's more favourable to him?
This offer is dated the 23rd of August 2018. At that point, the Soho Club had been taken out of the company. That was July 2018. But what hadn't happened is the Euston Club being set up and all of the Marylebone Club's business being transferred to the Euston Club. That didn't happen until February 2019. So if Mr McKeown had offered at this stage to accept an offer to have the shares in the company valued, it wouldn't have taken into account any of his breaches of duty that occurred in relation to the Euston Club. That's why I say it's more favourable.
It doesn't take account of breaches which the judge found which occurred later.
Exactly.
Breaches of directorial duty.
Yes.
Right?
Mrs Langer therefore had no option but to serve proceedings, which she did on the 2nd of April. And in her letter serving the proceedings, which is found at page 237, on the second page of that letter, penultimate paragraph, that offer of 23rd of August 2018 was repeated.
Yeah.
So it's not just the case that Mr McKeown failed to make any relevant offers that could be taken into account himself. He also unreasonably refused Mrs Langer's offers to dispose of the November trial, and instead Mr McKeown forced the petitioner to fight every single last issue, go to the vast expense and trouble of a 9-day trial with 5 separate experts producing 6 reports, 13 witnesses and 3 counsel. Ms Lang was aggressively cross-examined by Romy Taker QC for 2 days, and at the end of that, Mr McKeown lost resoundingly on every single issue, and the relief that was ordered, as I said, was less advantageous to him than that which had been proposed in August 2018.
The judge doesn't deal with these offers at all, does he?
He doesn't deal with these offers at all, but they were before him, my
Right.
lord. I did draw his attention to them. There was a without prejudice savers cost offer, which I tried.
Well, you wanted to put that in front of him, and the other side objected, and he said, "No, I
Exactly.
won't do it." Well,
And in the end,
that's fair enough, but these are open offers, and the judge doesn't seem to have taken any account of them.
he didn't. But I say that if this court's going to exercise the discretion
Yeah.
afresh, then your lordships should take it.
Yeah, right.
It's relevant to note that none of the authorities to which the appellant refers, even in relation to Part 36, deal with the situation in which the losing party has unreasonably refused an offer to dispense with the cost of the first stage of proceedings and proceed directly to the quantum or valuation stage.
Yeah.
So I say that whatever the terms of Mr McKeown's undisclosed called bank offer of May 2020, it couldn't operate to deprive the petitioner of her costs of the first stage of proceedings in circumstances where he had unreasonably refused offers to bypass that stage. And then finally, on the issue of circumstances, I'd like to address your lordship on the issue of impecuniosity. My learned friend seeks to contend that this is not a relevant consideration, and he may be right in his contention that the means of the parties to a dispute is not a reason to make a particular order per se. However, the argument in this case goes beyond merely the parties' means, because this is a case in which the cause of Mrs Langer's impecuniosity is Mr McKeown's conduct. Firstly, in depriving her of her only source of income since 2018 by his unfairly prejudicial conduct, and secondly, in his conduct of the litigation. It's no answer for my learned friend to say, well, parties must make sure they can fund litigation to its conclusion before they embark on it, because what parties aren't expected to do is to ensure they have sufficient funds to pay the unnecessary costs that the other side forced them to incur by their unreasonable conduct. And so we say that this is a relevant circumstance to which this court can and should have regard when determining this appeal. Now, it's true that Mr McKeown has now paid the interim payment 8 months after it was due, and only then to avoid a bankruptcy petition, and perhaps in an attempt to meet some of the arguments in this appeal. But notwithstanding there being no stay in place, Mr McKeown has still not paid a single pence towards the £450,000 that he was supposed to pay the petitioner in costs back in February this year. Further, as I've said, Mr McKeown now says he's
There was a time limit on the payment of costs, so he's in breach of the court order to pay, presumably.
Yes. There was no stipulated time limit, so I think the usual 14 days. Oh, I'm told that it was stipulated on the face of the order.
Yeah, right.
Because Mr McKeown now says he's insolvent, if this appeal succeeds and the costs of the first stage are reserved, Ms Langer is faced with an impossible choice. The judge has made very serious findings of wrongdoing against Mr McKeown, including that in breach of fiduciary duty he transferred all of the company's business and assets to himself and removed large sums of money from the company for the benefit of himself and his friends and family. The judge has also found that Mr McKeown acted sufficiently unreasonably in his conduct of the first stage of proceedings so as to justify an indemnity cost order. But in order to get to the point where she can have the issue of costs considered and that unreasonable conduct penalised, she has to incur the very significant costs of the valuation stage, as I've said, but must do so in the knowledge that she won't recover any of those costs, and Mr McKeown will not pay any costs that are awarded against him at the end of the day because he's insolvent.
Has there been a budget in the Preston date for the valuation stage?
No. Yeah.
Do you have an estimate of what your costs will be for that stage?
think the position is we hope that we can get it done for 100,000, but that is obviously contingent upon there being no further unreasonable conduct on the part of Mr McKeown, and his solicitors have already indicated that they're going to try and reopen the buyout terms by obtaining further expert evidence in relation to the valuation of the lease, which wasn't ordered by Judge Thompsell. Meanwhile, Mr McKeown is free to pursue the type of conduct that is referred to in Ms Scandrett's witness statement dated the 12th of May 2021, which is behind tab 12 of the supplemental bundle. I'm not asking the court to make a determination of fact as to the matters set out in Ms Scandrett's witness statement, but it will be seen that the petitioner's position is that Mr McKeown is seeking to dissipate his assets and put them beyond her reach for the purposes of enforcement. Mrs Langer's only alternative to incurring all of the costs of the valuation stage, which Mr McKeown has made clear she will never recover, is to permanently discontinue or stay the proceedings, they're currently stayed at the moment, in which case she'll recover no costs at all. Plainly, these are not matters that were or could have been before Judge Thompsell when he made his decision. But when this court is deciding where the justice in this appeal lies, I say it is relevant to consider what the implications would be in practical terms of the appeal succeeding. And I say it would cause extreme injustice to Mrs Langer. The final part of my submissions, my lord, is the question of what the implication is if the court is satisfied that the judge should have treated the call-to-bank offer as a Part 36 offer. And there are three strands to this argument. The first is that my learned friend accepts that in exceptional circumstances the court can make an immediate cost order notwithstanding the existence of a Part 36 or other offer. And the short point here is that we say the circumstances of this case are exceptional. And so even if the judge should have treated the call-to-bank offer as a Part 36 offer, he was entitled to make the cost order he did. The second point is relates to the undisclosed without prejudice savers to cost offer made by the petitioner in relation to the first stage of the proceedings. Now, it is true to say that the judge did not, as the hearing went, end up making a ruling as to whether that offer was admissible or not. But we maintain that it was admissible. And if the judge was going to be considering costs on the basis that call-to-bank offers are equivalent to Part 36 offers, then in my submission he was entitled to have regard to the fact that there was one admissible offer in our submission made by the petitioner in relation to the first stage of proceedings.
That's the offer you've just shown.
The open offer.
The open offer.
Sorry, no, I'm talking now about the offer that he didn't look at, and your lordships haven't either. There is...
Do you know, can you tell us what happened? Because what appears from the judgment is you wanted to put it before him in a redacted form, because some of the letters dealt with a global offer. And Mr Tager objected. And then it's just left there. Did you not press the point, or
So,
how was it left?
what happened was, there are parts of our without prejudice savers to cost letter that refer to the global call-to-bank offer. In the way that when solicitors write letters, they'll sometimes refer back to other letters and then make new points. There were parts of that letter that referred to the global offer, and then there was a separate section of the letter that dealt with a without prejudice savers to costs offer made by the petitioner that related only to the first stage of the proceedings, so only to the issues that were being decided at the November trial. That letter originally went into the bundle for the costs hearing in its redacted form. Brooke Martin, solicitors for the appellant, objected and said that if that correspondence remained in the bundle, they would invite Mr Thompsell to recuse himself. So on that basis, we took the letter out, put it into a separate clip of correspondence, and you'll see in my skeleton for the consequentials hearing, I made the submission to the judge that there were two types of without prejudice saved cost offer that he hadn't seen, one that related to decided issues, i.e. our offer, and one offer that related to undecided issues, i.e. the global offer made by Mr McKeown. And I asked the judge to look at our offer on the basis that it was admissible, but I didn't ask him to look at the offer by Mr McKeown. Mr Tager objected in very strong terms to any of the without prejudice savers to cost offers going before the judge. And what the judge essentially said was, do I actually need to decide whether your offer is admissible or not? Or can I just make a decision without addressing that point? And as the hearing progressed, it became apparent that it actually wasn't, in the way he was approaching costs, going to be necessary for him to decide whether our offer was admissible or not. And so he didn't look at it, and he didn't make a ruling on it. And his judgment is a bit confusing in that regard, because he refers to Mr McKeown's undisclosed without prejudice savers to cost offer in his judgment, but he doesn't refer to our correspondence. But it was before him.
Wait a minute. At this stage in your submissions, you have gone off the question whether we should exercise our discretion, or how we should exercise our discretion. And you've gone back to the question repercussions if call-to-bank offers and Part 36 offers are treated as being equivalent. There's no respondent's notice saying the judge should have looked at your stage 1 call-to-bank offer.
No, that's right, my lord.
I'm just trying to see how this fits into the shape of the appeal.
Well, I'm doubtful whether you can invite us to look at it when you didn't in the end.
Don't.
Well, if you don't invite us to look at it, it's very difficult to say that the judge should have taken it into account, isn't it?
Well, the appellant in this case puts forward a counterfactual, which is, and in the counterfactual, the judge was required to treat call-to-bank offers as part of 36 offers. And the point I'm simply making is that
If he gets in his, you get in yours.
in that counterfactual,
In that counterfactual.
exactly, all of the call-to-bank offers need to be treated as part of 36 offers. I agree that it doesn't assist your lordships with the exercise of your discretion. However, it is something that I feel it's important to draw to your lordship's attention.
But if the appellants are right, we're in a new situation in which we've got 2/3 of the evidence about conduct and so on, but we don't have the call-to-bank offers. So either we or on a remittal, the judge would have to look at such evidence as was now admissible, which would include all without prejudice call-to-bank offers.
Your lordship's quite correct. It's a point that really goes to remittal rather than to the exercise of the discretion afresh.
Yeah. All right.
The final matter, I'm told that in fact we do mention our without prejudice saves costs offer in our respondent's notice, my lord.
Right, where's your respondent's notice?
The respondent's notice is
Tab 13.
at tab 13.
No, I don't seem to have it. Very strange.
I haven't got anything in my call.
My call bundle doesn't have a tab 13. Loose? No. Sorry, I didn't realise there was one. My apologies.
Yes, paragraph 3 of the respondent's notice, 3.2. The respondent had made offers to settle the first stage issue for November trial that were not disclosed to the judge at the insistence of the appellant's leading counsel, but which ought to have been in the event that the without prejudice savings cost offer was said to be treated as equivalent to Part 36 offer.
If you have a spare copy of the respondent's notice, I'd be glad to have one, because for some reason it hasn't made its way into my bundle.
lodged late, my lord, which may be why. Yes. Was
It's
it
for me. Usher, it's for me.
I can hand up another.
You got one.
I have, yes.
You've got one, Christopher.
Well, I've got an unsealed and undated copy. But what you've just read doesn't seem to be the same as.
Well, Miss Lindner, I think you had better, or your instructing solicitor better send us whatever it is that has been
Yes,
sealed as the respondent's notice.
absolutely.
Well, just whilst we're on housekeeping, in the supplementary bundle, I'm missing tabs 9 and 10. If they could be provided, that would be useful.
The final strand to this fourth part of my submissions is that on any view, the appellant's offer was only capable of impacting on the cost on costs from 21 days after it was made.
Yeah.
The call to bank offer was made, as we know, in May 2020. That was more than 2 years after the dispute between the parties commenced in April 2018, more than a year after the petition was presented, and 6 months before the November trial. And on any view, I say the petitioner is entitled to her costs up to 17th of June 2020, which is 21 days after expiry of the offer, and she is entitled to a payment on account of those costs. Those costs are significant, and we say that whatever the outcome of this appeal, Ms Langer should walk away with an order that Mr McKeown makes a payment on account of her budgeted costs up to that point. My learned friend makes 3 submissions in relation to this point. Firstly, he says that it would introduce unnecessary complication into the process. We disagree. We don't think it's complicated at all. And in any event, I say that complexity is not a good reason to keep Mrs Langer out of money to which she is otherwise entitled and which she needs. I note that the authority relied upon by my learned friend,
Judge Pelling, his robust statement.
in lifestyle equities.
Yes.
But that was a dispute between 2 commercial parties, my lord. The situation here is quite different.
We note it as it's typically robust of that judge. Well, he treated it as effectively as a rule that you can't recover your pre-Calder Bank offer costs on the basis of complexity. It seemed a rather inflexible rule.
My lord, I say that isn't a rule.
It's a discretion in any event.
It's a discretion, but there is a presumption. Just dealing with the pre-Calder Bank issues. There seems to me to be no reason in principle why a party shouldn't have their pre-offer costs. I don't understand there to be any hard rule that that's the case. I say that is not a decision that your lordships are required to make, or not required to follow lifestyle equities.
Yep.
The relevance of the party's means and the ability of the parties to carry costs to this question of whether there should be pre-offer costs ordered was, as we saw earlier, referred to in Tullett, where one of the reasons that the judge gave for deciding not to make a separate order regarding pre-offer costs was because the claimants were a substantial company that were able to carry the costs of the litigation. That's not the case here. It's not just a case of solicitor and counsel fees which are covered by a CFA. It's also the disbursement of experts, and it's also insurance costs. It's also other costs that are not covered by a CFA. Secondly, my learned friend says it would serve no useful purpose to sever the pre-offer costs from the remainder because Mr McKeown might be awarded his costs from 17th of June onwards and there will be some kind of settle. With respect, that can't be right. Firstly, we say it's highly unlikely. We say that Mr McKeown will recover any costs at the conclusion of proceedings, and even on the appellant's costs, it's possible that he won't recover any costs. The second stage of proceedings is currently stayed. There's no guarantee that it will proceed proceed, or indeed when it will be concluded. It's true to say that Mrs Langer has now received the payment of £200,000 of cost payment, but one has to remember she hasn't had any income since April 2018. So it's not the case that she can simply take that chunk of money and throw it at the second stage of proceedings. That is not a payment on account of costs, that is a payment on account of her damages or the valuation of her shares. And that's money that she is entitled to, not money that to be applied to costs. And of course, she will apply some of it to costs if she can of the second stage of proceedings. But one can't just look at that pot of £200,000 as being a pot that's available, a fighting fund for the second stage. The second reason I say that this point is wrong is that where the court makes a cost award on a preliminary issue or interlocutory application, there is no principle that the paying party is permitted not to make payment until the conclusion of proceedings, in the hope that they'll be able to set off a cost order in their favour against the sums owed. Where you have an interlocutory hearing and the court makes a cost order, the paying party has to pay that cost order straight away. And they're not allowed to say, well, I might win at the end of the day and then be entitled to set off.
I think we know that.
Yes. And in fact, my lords, this precise issue was considered in multiplex behind tab 9 of the authority bundle. At page 90, so CB had made an application for payment on account of its costs, and
Paras 43 and 44.
exactly, yes.
Yeah.
And I say the same logic applies here. Even on the appellant's case, it's not clear what the overall cost position will be at the end of the day, but the one matter which is clear at the moment is that Ms Langer is entitled to her pre-offer costs, and so I say there should be a payment on account of those. And then finally, my learned friend says that to make an order now would fetter the court's discretion in the future to decide to deprive Mrs Langer of those costs entirely. The problems with this argument are that firstly, he's already accepted and indeed relies elsewhere in his submissions on a concession that but for the Calderbank offer, Mrs Langer would be entitled to her costs. And that Calderbank offer is only capable of affecting the costs after it was made. And secondly, the judge has already found that there was no real prospect of valuation process finding that the petitioner's shares are worth less than the £25,000 offered on an open basis by Mr McKeown. And I'd remind your lordships that the judge made an interim payment order of £200,000.
Yeah.
So we say that whatever happens, Mrs Langer is entitled to her costs up to the 17th of June 2020 with a payment on account in the amount of her budgeted costs. My lords, those are all the submissions I was going to make. I don't know.
Just before you leave that point, you said payment on account in accordance with the budgeted costs, but we were told that these budgeted costs, which come out as 168,000, were not before the costs management order hasn't approved this budget because they were incurred costs, and so they would be subject to taxation assessment on the standard basis.
Yes, they would.
So we wouldn't, even if we accepted all your arguments to date, just award you the sum of 168,000. How much would we order by way of interim payment?
Well, my lord, the judge below was content to order a sum that was more than the total of the petitioner's budgeted and incurred costs.
But that's because a large part of the later costs, trial and trial preparation and experts, were on the indemnity basis. But I didn't understand any of these costs to be awarded on the indemnity basis. So if we were looking at this, incurred costs on the standard basis, you have to put a figure which you invite us to make an award of an interim payment in relation to, don't you?
Yes, may I just take instructions briefly? 75%.
Right, thank you very much.
Thank you, my lords.
Mr Cohen, did you wish to reply?
My lord, I do. I'll be as brief as possible. There are a few points that I do need to come back on. Perhaps I can clear out of the way, I hope, first of all, this business about the WP savers to costs material that the petitioner wanted to put before the deputy judge, in which he did not see that you were hearing submissions on a moment ago. This was put to your lordships on effectively a sauce for the goose, sauce for the gander sort of basis. And that is, in my submission, a mischaracterisation of what this issue was about. The petitioner said that there were offers which had as their subject matter stage 1, if I can put it that way, and were therefore admissible at stage 1 simply for that reason. And the opposition was that because the letters that contained the material on which the petitioner wanted to rely also addressed other matters, even redacted, it wouldn't be appropriate to put them before the judge. And in the face of that opposition, the point was not pressed, the judge was not asked to rule on it, and in my submission, that is an end of the matter. They no longer fall for consideration. It's not part of the factual matrix, whether mentioned in the respondent's notice or otherwise. We don't have them in the bundle. That's all there is to it. To come on to the substance, picking up, first of all, an observation made by my Lord Justice Lewison. Just to be clear, the judge did not exercise a discretion that took into account the existence of the offer. And my Lord put to my learned friend in the course of her submissions a point that I make in my skeleton argument, which is that when he's addressing conduct, he's not doing so with half a mind to the fact that there is an offer out there. He simply made a determination that before coming to offers, it was right that my client pay the costs to date. His approach to the offer was simply that he could not take it into account. The rules did not allow him to do that. And if he was wrong about that, then that is an error of principle, and the discretion was exercised in a flawed way and must be exercised again.
Yes, I'm not sure that it was quite a bright line as saying the rules precluded him from taking it into account. He said, well, even if they don't, I don't know what I'd do with it because I don't know anything about it.
Well, that was, if I may put it this way, a subsidiary point to his starting point being, well, it's not an admissible offer. The rules talk about admissible offers, so what am I supposed to do, in effect? It did not form part of the package of considerations that went into his decision. There is, in my submission, a key difficulty at the heart of my learned friend's submissions, and it arises from something that she said actually very early on in her submissions. She said she accepted, in principle, that there might be circumstances in which, because of a call-to-bank offer, an order for costs made there and then might need to be changed down the line, and that for that reason it might be appropriate to reserve the costs. Now that acceptance, which I say my learned friend was bound to make, but it's crucial because it rules out by itself the absolutist position which the deputy judge took. It necessitates consideration in some form of the offer, because that acceptance carries with it, of necessity, the possibility that actually justice might require the costs to be reserved. And the answer to that, or where that necessarily leads, and the answer to so much of what my learned friend says, is how can you then exercise that discretion judicially if you do not know what the offer is? The single most important thing that you need to know if you're going to exercise that discretion judicially is what are the terms of the offer, and you cannot know it. And I'm not going to engage with the submissions on conduct. The findings are what they were. I'm not going to engage with the submissions on offers made by the petitioner. They exist, they fall for consideration. But without knowing the terms of the offer that the court could not know, that consideration is an incomplete consideration, and one which carries with it a substantial risk of injustice.
Just argue about I'm just looking at paragraphs 21 to 23 of the judgment. Judges, I'm not sure that the offer does amount to an admissible offer to settle of the type referred to in 4424C. I think its existence is something I should consider, and I've fully considered the point, taking into account counsel's representations. How are we to analyse that? I mean, in one sense, he's saying, well, I'm not certain it's admissible, but I think I have taken account of its existence.
That's the open offer, my lord.
That's the 25,000.
That's the first. That's
£25,000
£25,000.
open
You're
offer.
right. Sorry, that's 22. We get that's right. 25 onwards is the.
Yes, we don't even
Sorry.
start on this aspect of the case until
Yes, you're quite right.
paragraph
No,
25.
absolutely. Yes.
The possibility of a bad faith or derisory offer, I said to a large extent what I want to say about that in my opening submissions, but 3 points are in my submission important. Firstly, it arises equally under Part 36. Yes, you have to agree to pay the claimant's costs, but you could make a Part 36 offer for £1, knowing there isn't the slightest chance that it will be accepted, and you will have made a Part 36 offer. Secondly, lest there be any suspicion of implication in my learned friend's submission, so I'm sure she didn't mean to imply this, there is no basis for thinking that is what has happened in this case. That is a necessary aspect of the fact that this court should not speculate as to the terms of the offer. There is no basis for thinking that it is a tactical or derisory offer. And the third point is this. One can't legislate for that possibility unless one is going to take a sort of Leninist approach to this and say it's better that 99 innocent men are convicted than that one guilty man goes free. The obverse is, well, you should never reserve to deal with the possibility that there is an offer made in bad faith, a derisory offer. And if one is going to compare the injustice on each side in my submission, it's very obvious where the balance tips. And as soon as one ceases to be absolutist, then one immediately comes back to, well, if you don't know the terms of the offer, how are you supposed to deal with it? And then again, this also comes into asymmetry, my lords. Again, I said most of what I want to say about that in opening. But again, the very important point is that these sorts of considerations are case-specific. My learned friend said, well, unfair prejudice petitions tend to be like that. My lords have already made the point that there are other areas of litigation that can also be like that, such as intellectual property claims. So unless one really is going to carve out whole areas of litigation from the principles that apply elsewhere, and I do say that it would have to be a fact-specific inquiry in any event, then one can't construct a guiding principle that can simply be applied. Oh, it's an unfair prejudice petition, well, therefore, we're going to say there's asymmetry of information, and therefore we know this offer isn't going to bite. It's going to be case-specific, and the only time that you can really consider it properly is at the end of the case. And the difficulties that my learned friend says the petitioner faces in this case should not be overstated. We are not in a position to conduct the investigation that might be required to decide whether it really would be unjust to give effect to an offer, the terms of which we do not know. What we do know is that the court ordered the parties to give open, non-binding valuations of the shares in March of 2020, or that's when it happened. And in March of 2020, which is 2 months before this offer was made, the petitioner put a figure of £1 million on the value of the shares. Now, we don't know why, but there must have been some basis for that. She felt able to put a figure on it. So the statement that this is a case, and this court should accept that this is a case, where there was an impossibility of the petitioner properly evaluating any offer, so the court can be wholly confident here and now that that offer could never be relevant to the incidence of cost down the line, cannot be right in my submission. And that may be a convenient moment to deal with the point that was put to me in argument this morning, and I have now found something helpful in the White Book on this, to what extent call-to-bank offers can be given effect along the lines of a Part 36 offer. And there are a couple of helpful observations in the White Book. And if I could invite your lordships to go to page 1465. about 2/3 of the way down the page, there is a paragraph that begins where a party makes an admissible offer. This is just a 3-line passage, and then achieves a more advantageous result. I should say, just to orientate your lordships, on the previous page, we see, or rather on 1463, we see that this is commentary on admissible offers to settle. Yeah. So we're clearly not dealing with Part 36 here, we're dealing with call-to-bank offers. And it says here, it may well be appropriate for the court to order the party which rejected the offer to pay all costs since the date when that offer expired, and there's a reference to Lord Justice Jackson's judgment in Fox and Foundation Piling. Over the page at 1466, there's also an illuminating passage at the top of that page, the paragraph beginning the automatic cost consequences. This deals with withdrawn Part 36 offers. So if you withdraw a Part 36 offer, you no longer get the automatic entitlements. It falls to be considered like any other call-to-bank offer. But there is a fair amount of case law, and there's reference to the Stokes case, which is the case that sprang to mind when my lord put it to me this morning. I won't read out the whole of that paragraph, but I do pick out in particular this observation, that where, on the basis of the authority of Stokes Pension Fund trustees and Western Power Distribution, that where a purported Part 36 offer is made and then withdrawn, the crucial question is whether the offeree acted reasonably or unreasonably in failing to accept the offer while it was on the table. And that's another dictum from Lord Justice Jackson. If costs have been incurred because of the unreasonable conduct of the offeree in failing to accept an offer which ought to have been accepted, then the offeree will usually have to pay those costs. So I don't say, of course, that you get the automatic benefits of Part 36. Of course you don't. But there's very clearly no rule that if you can make a Part 36 offer, you should. It's part of all of the circumstances, which again reinforces the difficulty of deciding at an interlocutory stage, when you don't know what the terms of the offer are, that there could be nothing in the offer which could ultimately affect the incidence of cost. Turning to another point, my lords, my learned friend sought to make good a submission that the treatment of Part 36 offers comes from the rules of Part 36 itself. And she took you to the original Beauty decision. Now, it's certainly right to say that in that case, the deputy judge took the view that the current wording of Part 36 does indeed mandate this treatment of offers. The deputy judge in that case went so far as to say that the current wording of Part 36 actually trumps multiplex and removes even the possibility of not reserving the costs in an exceptional case. I don't go that far. I don't need to go that far. But the point is that that is one recent case referring to a particular instance of the rules. As the principle was developed in HSS, it had nothing to do with any part of Part 36. It was simply an application of considerations of fairness, policy, and also the wording of Part 44, which required the material to be taken into account. And on that, my lords, there was some debate between your lordships and my learned friend about what weight one should put on the word admissible in Rule 44.2. In my submission, its purpose is really to make clear that truly inadmissible offers, for example, without prejudice offers, purely without prejudice offers, don't need to be taken into account. But the way, perhaps in this context, the word ought to be read is to the extent that it is admissible, the court must take the offer into account. So if it's admissible only to the fact of the offer having been made, then the court must take that into account. If it's admissible as to the party that made it, the date on which it was made, and so on and so forth. And if there is an argument that it's truly, totally inadmissible, well, then its existence, or the possibility of its existence, if one even has to go that far, comes in under all the circumstances, as in the Ted Baker case. The extended reference, my lords, to the possibility that an O'Neill and Phillips offer could have been made. It really comes down to a submission which can be made in any case of this kind, that the offeror of the global offer could have made an offer that just related to stage one. But the particular significance of O'Neill and Phillips is, of course, that an offer of that kind, if made by the party alleged to have acted prejudicially, can provide a substantive defence to the petition, indeed lead to the petition being struck out. Here the offer was made by the petitioner. In the petitioner's hands, it's simply an offer to dispose of stage one on particular terms. If my client had made an offer of that kind, it would have been similarly an offer to dispose of stage one on particular terms. But saying to the global offeror, well, you could have made an offer that would have engaged with stage one, doesn't, in my submission, answer the point. Doesn't answer the point that there is nevertheless an offer out there which might yet bite, any more than, as appears in the authorities, saying, well, you could just have conceded liability. Doesn't answer the point. It doesn't remove the potential injustice of the offer being out there and ultimately being a good offer which ought to have been accepted. Just two final points, my lord. Firstly, on the relative prejudice, and particularly the financial positions of the parties. There has been, I do say, a certain amount of shifting of the ground here. The argument was put prior to the satisfaction of the interim payment, very much on the basis that this was what was denying the petitioner the ability to proceed to the quantum stage. And indeed, a submission along those lines was made in Mulleniferin's skeleton argument for the interim payment application. If I can invite your lordships to turn up in the supplemental bundle at tab 9, so I'm afraid my Lord Justice Green may have some difficulty here, and we will ensure that those deficiencies in his bundle are remedied. Page 163, this is part of the petitioner's skeleton argument on the, on consequential matters generally. And at paragraph 25, we see it said, the petitioner's disbursements funding has been exhausted, largely due to the unreasonable manner in which Mr McKeown has conducted this litigation to date. It would be wholly unjust for the petitioner to succeed in all the allegations of unfair prejudice and to now be shut out of the valuation process because she is denied access to the money that she has been kept out of by Mr McKeown's unfairly prejudicial conduct. And in the paragraph above, we see that what the petitioner was asking for was an interim payment of £500,000, but for half of that to be held in her solicitor's client account, so to deny herself the use of it. So what she was saying in those two paragraphs was, I would like an interim payment that I can use of £250,000, and that will enable me to proceed to the quantum stage. Now, the petitioner has had an interim payment to her for her own use of £200,000, and it is therefore surprising in those circumstances for the court to be told that actually that does not necessarily allow her to proceed to the quantum stage. Now, if the petitioner were to receive any costs on top of that, those would necessarily be defrayed to her legal team and her after the event expenses insurer. It does not appear that the petitioner has incurred herself much in the way of legal costs at all. And indeed, the portrayal of her as someone who is struggling to take these proceedings forwards is very much at odds with the way she was sought to be portrayed at the outset of these proceedings. Your lordships were shown Russell's letter of the 2nd of April 2019, which contained the reiteration of the earlier
Where is this going?
offer. Well, my lord, it's relevant because a lot of weight is placed by the respondent in her argument petition on the iniquity, the supposed iniquity of an immediate cost order being made in circumstances where it said that she is impecunious and she is facing an impecunious party herself. Now, the impecuniosity should now have been remedied on the basis that she was asserting it existed.
Yeah, well, you've made that point. You made that point in
Yes.
the appeal.
As far as Mr McKeown's position is concerned, his impecuniosity is simply a fact which is wholly independent of whether this cost order stands or doesn't. If the interim order stands,
about his finances, we don't know what he's done with the money. I mean, we're not in a position to know that, whether it's correct or not.
well, my lord, you're not, and I would certainly urge the court to be wary of making those sorts of comparisons. I mean, we're hearing suddenly, for example, suggestions of dissipation of assets. This was something which arose in an exchange of witness statements, which appears in the supplementary bundle. If your lordships have any interest in that, you can see in Mr. Martin of Brook Martin's statement the answer to that. We say there's nothing in it. But we are, in even considering these matters in my submission, getting really beyond what are the relevant considerations.
Yeah.
And then just finally, my lord, on the question of set-off, in arguing that it would not be appropriate if your lordships were to make an immediate order pre-offer for there to be an interim payment because it would deny my client any right of set-off, that is not about not paying as one goes, which of course is the normal way. It's about not allowing one party to steal a march on the other in circumstances where otherwise costs would normally be dealt with in the round at the end of the case, and a set-off would be the norm. Yeah. My lord, those are my submissions.
Thank you very much, Mr. Carpenter. Well, thank you both very much for your very interesting arguments. There is obviously much food for thought. It will not surprise you to learn that we are going to reserve our judgments. You will get a draft in the usual way, which will be your opportunity to correct our grammar and spelling, but not our reasoning. We would hope that in the light of the draft judgments, you will be able to agree a form of order disposing of the appeal. But if you can't agree a form of order, please make short submissions in writing, and we will make the order that we consider to be appropriate. Thank you all very much.
Right.